those who are involved in this, while dealing in securities in order to induce another person with his connivance. So all the person, those who are the party to the connivance, that is also responsible, or his agent, to deal in securities. Whether, now this is very important, whether or not there is any wrongful gain or avoidance of any loss. So you can understand that if you are doing, it is proved that you have done some fraud with the connivance of some other person or along or by yourself, and it is proved, even then there is no wrongful gain, or even then you are responsible. Now they have added one word, avoidance of any loss. So sometimes you say that I have not gained anything, but by your action you have avoided some loss. That is also violation. Friends, the regulation specifically prohibits dealing in securities in a fraudulent manner, market manipulation, misleading statements to induce sale or purchase of securities, and unfair trade practices relating to securities. SEBI can conduct investigation, they can do suo motu, or they can go for any information or any complaint through an investigation officer in respect to conduct an affair of any person buying, selling, dealing in the securities. Based on the report of the investigation officer, SEBI can initiate action for suspension or cancellation of registration of intermediaries. If intermediaries involved, they can forfeit the amount. They can suspend your license. They can freeze your bank account. They can freeze your demat account, and they can take any action. And they can say that you are suspended from the raising, buying, and selling the capital market. And after the investigation is over, because they have a power of 11B, where they can pass an interim order, and after the finality of the order, they can take further actions. To give you all the bird's eye view of this program, we will delve today what fraud is, particularly market fraud and market abuses, type of market fraud, how these fraudulent activities operate, how SEBI identified them, investigate and take enforcement action. Next is power of SEBI regarding market abuse and fraud coupled with duties and right of the persons, investors subjected to inquiry, investigation or enforcement by the regulator. Learning from the past and the way forward. And then after this, I'll give some suggestions to the regulator related to how some new out-of-box things can bring out to safeguard the market. Today, we have a distinguished panel of expert speakers who will share their insight and experience on the subject matter, because they are handling investigations and inspection cases. We have eminent speaker for today's webinar, Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Professional. Then we have Ms. Nikita Vijay, Senior Associate, Securities Law and Corporate Litigation, Corporate Professional. And then Ms. Ankita Agrawal, Associate, Securities Law and Corporate Litigation, Corporate Professional. All these three persons, they are day and night doing work on this. Friends, the speaker embark on the deal with the aspects I just mentioned. Let me introduce the need and significance of the holding a knowledge sharing webinar on this contentious topic, because every day in the newspaper we are seeing the SEBI has taken action, or front running SEBI has done action on some companies. SEBI is doing investigation of some companies. The Supreme Court is also involved. They are also doing the SEBI should do this. So this is the current topic where everybody is interested to know. Friends, in a digital era, the stock market has opened up new horizon for market and participants, among them investors. But unfortunately, however, fraudulent activities also run rampant. To dal mein paat, this is the concept where always chor sipahi game is always going on. These deceitful activities can have multiple effects, consequences for the investors and the overall stability for the growth of the market. Because India is the country which has the highest number of the savings, and this saving is not channelized in the capital market. This is saving is channelized to unproductive asset. If it is channelized in the stock market, the country can grow multiple. But whenever the one fraud, two fraud, three fraud, or this type of investors loss is there, then the normal investors, they always leave the market and they invest in FD where they are not getting any effective in return. But that is a safe. So safety of the market is more essential to have impact on the Indian economy. Fraud generally refer to an act of deceit, misrepresentation, omission of facts by any person or entity involved in the security market, which may cause misleading inducement in the market or interfere with the principle of free market and demand and supply. As you are aware that this Indian capital market is free market. You can bring out IPO at any amount. SEBI is not restricted. They are saying you disclose and then you can bring out whatever violation you have done. Even then you can bring out if the investors are ready to take your shares. So this is a free market on the basis of demand and supply. Now fraud can take many forms because it is not the one type of fraud is available in the market or only one. Multiple fraud we have seen. Now I'm just categorizing the intermediaries fraud, where research report, investment advisory fraud, where you are giving wrong information, unauthorized trading, dabba trading, co-location fraud, front running fraud, that is also taking place on the intermediate side. Then there is some fraud on the market trading side, that is a market manipulation, insider trading, circular trading, price volume rigging, synchronized trade, LTGC fraud, reversal trade in F&O segment that we have seen in so many cases. SEBI has passed an order. Then company fraud, illegal fundraising, IPO fraud, where you are giving wrong information or you are violating law, Ponzi scheme fraud, GDR fraud, accounting manipulation and misgovernance. That is a fraud which is rampant because everywhere it is coming out that accounting manipulation is taking place, and by you are showing wrong profit, wrong information to the investors. Now, all these types of fraud which I have just categorized, Nikita will tell you in detail about these fraud, but I have highlighted that these types of frauds are taking place in the market. Now, market fraud can also involve misrepresenting company performance, asset liability, or any other information that can influence, otherwise induce investors' decision. Okay, so you can understand market fraud can also involve misrepresenting, and sometimes you can give wrong information. SEBI's view any instance of market fraud or abuse very seriously. They in the past give sufficient proof of SEBI's action on fraudster and manipulator. Moreover, SEBI's attention towards the instances of market fraud and abuse has deepened all the more now because of the recent enormous participation by retail investors in the market. Also because SEBI has standardized and automatized many routine compliances associated with advanced technology, which is on ongoing exercise. It now has the time and determination to take market fraud abuses by its own, because market fraud is always not good for any economy. It is directly affecting our economy. It has become common knowledge that post-COVID era, when the market crashed in March 2020, retail investor participation in the stock market has witnessed explosive growth. When the COVID, we have seen the lockdown period, and that time the people were sitting their home. So many professionals, so many persons, they have started investing in the capital market. And this is an indication that in March 2020, the number of Demat account was 4 crore 9 lakh. Since then, the number of Demat account has steadily risen to reach 10 crore in August 2022. You can understand that how many, more than 6 crore investors had joined. And this is not only joined, it is reflecting in their trading also. Retail investors now account for 52% of daily transaction in the market, where domestic institution and FIs accounting for 29% and 19%. Domestic 29 and FI to 19%, respectively. Clearly, the equity cult in India is spreading. Previously, when the FIs were buying and selling, market was moving. Now, domestic investors are also going ahead and they are higher than the FIs. But FIs and the domestic investor both together, the retail investors are more now. There is 52%. So you can understand the market, more and more people are joining and more trading is taking place. Retail investor participation in the equity market is desirable, eventually contributing to higher capital formation and economic growth. But it is must that they are protected against market abuse and fraud. Because these retail investors, they don't have a research report, they don't have a infrastructure, they don't have a knowledge. They are investing because the market is going up and because of there is wrong information. So when the investors has come to the market after a long time, because we have seen 2000 fraud, the investor has gone away. Then 2008 investor has gone away. Then again in between 2014, 13, and then 20 also. So today now investor has come back. We must protect this. The regulator has to establish various mechanisms to prevent abuse, fraud, and detect and punish. If it occurs, the disclosure-based regime on which that securities law framework is based in India is a preventive policy measure that helps a great deal in keeping market abuse, fraud at bay. But there is an acceptance among experts and regulators globally that market fraud abuse cannot be removed entirely from the market. So policy making, surveillance, investigation, and enforcement of the law is a continuing essential exercise, and SEBI and its allies must always be on their toes on a war footing. The saga starts with the monitoring, trading, and the market activities through state-of-art surveillance capabilities, followed by investigation, and that is a very effective investigation team and knowledgeable people should be there. If red alert are found, in appropriate cases, enforcement actions are taken, which may be preventive and penal in nature. And on top of all this, SEBI continuously work for the policy development as well as investor awareness to keep up with the dynamic and ever-evolving nature of the securities market. As we have interact today, SEBI continues investigating several matters for possible market abuse, fraud from multiple dimensions, and in testimony stands the order regularly being passed by SEBI. This emphasizes that is taking place regularly, and the regulatory bodies are closely monitoring the securities market and are dedicated to prevent, detective, and punishing of fraudulent activities and malpractices. But we have to see this, that more has to take place. This is not sufficient, because when the SEBI bring out something, what is happening? Doing some manipulation and then bringing to the court of law. In that, there is a big gap. You can, on the prima facie, you can fix responsibility, but in the court of law, when you want to give a punishment to these people, you have to bring everything on record. You cannot leave anything on the basis of your perception. So you have to bring out record, and that record is always not possible. So the regulator has to evolve system, evolve law, and more things should take place. One cannot emphasize enough that compliance with securities law and regulation is crucial for maintaining investors' trust and ensuring a fair and transparent market. Therefore, the speaker today We'll touch upon certain fundamental concepts of the securities market necessary to understand the complex nuisance involved in the legal framework dealing with market fraud and abuse. We hope this session will be informative and valuable for all the attendees. And friends, after the program, after all the speaker and the Q&A session, we have received some questions. You can send your questions. I will give some suggestions to regulator, which on the basis of our experience and on the basis of the new system which is developing. Before I hand over the speaker, I must express gratitude on behalf of Team Corporate Professional to our all participation in huge number in our journey of knowledge sharing. To further enhance the reach of knowledge sharing, we have published a wide range of informative and knowledge material on our website, www.corporateprofessionals.com, and YouTube channel by the name of Corporate Professional, where you can also access the recording of webinars on diverse topics. Before handing over, we have to just see whether the regulator which are evolving the new system, it is sufficient or not. That I will discuss everything after the question answer and give some suggestions on some solution that how we can improve further. Friends, now I will request Nikita Vijay. She is working in the security market and she has done the various identified the various issues relating to market fraud investigation. So I'll request Nikita to share her thought.
Thank you so much, sir. Thank you so much, sir, for sharing our insights on the fraudulent and unfair trade practices in securities market. Now, in continuation, I would like to first explain that how the fraud is defined under our legal provisions. So as sir also pointed, so fraud is basically defined in SEBI fraudulent and unfair trade practice regulations under regulation 21C. So there are certain key ingredients in that regulation which are very important to consider. And courts and tribunals in various cases have interpreted the scope and term of fraud in their judgments. For example, the definition of fraud as given in the regulation is an inclusive definition. Secondly, as sir also pointed out, that whether an act or omission has been done in a deceitful manner or not, irrespective, it will be considered as fraud if it has been proved that any inducement has been occurred and any genuine investors have been impacted due to that act or omission. Further, whether there is any wrongful gain or not, or if there is any avoidance of law, is not something which is so the legislature has specifically included these terms to widen the scope of fraud so that no market schemers impact the securities market and create fraudulent schemes in the market to impact the genuine investors. Further, it has also been mentioned that fraud includes an act or omission. So it is not necessary whether you have done something and that has contemplated to fraud. It might be an omission on your part, which has impacted the securities market in general and impacted the price or volume of a particular script. So that also is included in the definition of fraud. Such interpretation and the scope of term has been defined in Shri Kanhaiya Lal Baldev versus SEBI in the Supreme Court. And the scope of the presence of inducement, whether there is no requirement of any deceitful manner, that all these interpretations have been done in Shri Kanhaiya Lal Baldev versus SEBI by Supreme Court. Further, it is very interesting to see that Indian courts have adopted this negligent standard test. So what is negligent standard test? Negligent standard test is basically where an intention to prove your conduct is not necessary. So whether you have done the fraud to prove your intention was to fraud the securities market or not is not a concern in the Indian legislature, and the regulations and the definition have been construed in a way that uh, that it is not necessary for you to for your intention is considered a mens rea is not a essential ingredient while concerning fraud. So, although if you see our Indian laws and Indian jurisprudence have been adoption of mostly of the American counterparts, where anti-fraud provisions are there in US securities law. Although it is contrasting, it is interesting to say that it is contrasting in the American jurisprudence. So Supreme Court in the US Supreme Court in Ernest and Ernest has said that negligence standard test should be there in the fraudulent conduct. But if you see the legislature between the Indian definition and the foreign definition, so our Indian legislature says that intention is not necessary, but contrasting to the foreign laws, it specifically says that it should be with a deceitful manner. Then only a case can be considered as fraudulent or a act can be considered unfair trade practices. Also, if I'll just go coming forward, so if you see the SEBI's perspective, what kind of fraud which we have been seeing in recent times, there are certain fraud which are related to intermediaries. There are certain investment and research report which have been published in the public domain, which impacts the price of the particular scrip, but they were not authorized to publish such reports. There is unauthorized trading by the brokers. There are certain violations recently have been recognized through mutual funds also, that they have not disclosed the proper information, or they have moved the high risk investments to the low investment schemes, which were recently one of the case was settled with SEBI ICSA mutual fund. Then there is NSE co-location fraud, which has been on talks of the town for many time in recent years. And the case of front running, there's in where a person is setting up a person not himself trading in the securities market, but creating a situation where uh, somebody else is trading, and uh, they are taking advantage of that particular scheme. Then there are many trading frauds related to market manipulation, insider trading, circular trading, price volume rigging, where price and volume manipulation is there. In certain cases, there is price manipulation where where the price of the script goes high, and people take exit at a higher price. But there are certain cases where the intention was to create the liquidity in the market, to create the volume in the market. And how does these trades happen? How does these manipulation happens? We'll discuss later in the webinar. Then there is synchronized trading, where two persons have a prior meeting of minds, and they are trading on the anonymous platform, but they are doing it in a synchronized manner. Then there's reversal trade in FNO segment. One of the major case in this trading fraud was Rakhi trading, wherein various legal principles were set to say that the fraudulent and unfair trade practice can also happen in the FNO segment. They have also stated in the Supreme Court have also stated in their order that since derivative market there is no change of beneficial ownership. So their plea was that when there is no change of beneficial ownership, how it can be termed as fraud. But Supreme Court has specifically stated that when there is change in hands of the contracts as well, so fraud can also happen in FNO segment. Then there are frauds related to companies, where illegal fundraising, IPO fraud, where where companies are coming with IPO and they are not disclosing the appropriate information or misleading information or something which has happened on the higher valuation, which should not be. And the genuine investors investing the money based upon the prospectus that has been issued by the shown by the concerned issuer companies. In recent time, there were a lot of cases with respect to GDO frauds, when there were a lot of companies which has come up with the GDRs in the foreign market. But when we delved into the nitty-gritties of those GDR mechanism, there was no actual money that was inflown in the Indian market. And based upon this information, genuine Indian investors are invested in securities market, and this has been done by many of the companies, and that has been taking many although the modus operandi has been not challenged in SAT, but SAT has recently cut down the penalties, considering that the manipulation and fraud, the gravity was not coherent with the penalties and direction that were given to the companies and their directors. So moving forward, if you see what are the common reasons for frauds and why they are not detected at an early stage. So they're diminishing ethical values. People think that they can make quick money with incorporating these kind of schemes in the market, which ultimately impacts the normal retail investors. And then there are poor governance on the part of the company. There are ineffective internal control systems. Companies are not they are not complying in letter, and they're complying just for the sake of the complying with the provisions, but in spirit they are not complying with the regulatory provision that are in place to prohibit such kind of frauds. There are regulations regarding that there should be a proper and fair disclosures to the investors. So all these factors should be factored in and should be taken care of by the companies as well. Since securities market is, as we all know, securities market is a very highly volatile market. One small information makes the price of the script higher. Also, one negative information get the price of the script get lower down also. Sorry. So there is lack of investor awareness. We generally rely on the information that is available in public domain, or there are various telegram channels, and there are various mode of, now since the uh, digital area has been a very at a very high stake, and it is accessible to almost everybody. So people are very lucrative with these information, and they invest on without going into the fundamentals of the company, without going to a registered advisors as registered with SEBI. They invest based on these rumors and information. So I think these all things we should, as an investor also and at a company levels also, these are the things we should consider before investing in the securities market. So if you say the investigation that has been going on in PFUTP cases by SEBI, so in 1920, almost 35 new cases SEBI has taken up. And with respect to the old cases and new cases, altogether 39 cases were completed. In 2021, also 41 new cases were there in the FUTP, and 46 investigations were completed in these cases. In 21-22, 38 new cases were there, and 82 were completed in 21-22. So you will see after COVID, SEBI has been very proactive in concluding and culminating these investigation matters regarding FUTP. Then if we see the adjudicating orders, so there also you can see an increase. In 1920, there were 984 adjudication orders in respect of FUTP. In 21, there were 901. In 21-22, there were 1005. So moving forward, I just want to make you aware of certain important parameters that are taken by SEBI while investigating the matters regarding FUTP. So the one thing that they see while investigating is the meeting of minds. Whether there is any meeting of minds between the buyer and the seller. For example, in a case of a price manipulation or volume manipulation, these tradings are done on the anonymous platform of exchanges. So if we are doing a genuine trade, how you can demarcate a genuine trade from a fraudulent trade? So they say that there must be a factor of meeting of mind between the buyer and seller. So if buyer and seller knows each other, they put a order at a same price or at a same quantity or at within a fraction of seconds. These are the parameters they see to check whether there is any meeting of minds or not. This has been so in certain cases when there is no connection drawn between the buyer and the seller. So in many of the cases, SAT overruled SEBI's order that when there is no connection between the buyer and seller, a fraud cannot be proved against the delinquent. So in recent case of Saurabh Kumar Podar and others versus SEBI, similar thing has happened. Since there was no connection established between the buyer and seller, so SAT overruled the judgment of SEBI, saying that there is no meeting of minds. So other than the trading pattern, what are the things they use to draw a connection between the parties? So connection can be based on the various things. There may be a call, they seek call data records, whether there is any correlation between the trading and the call data records, whether your KYC details from the broker, there is any commonality between the KYC details of the entities within that group. Then there is uh, if there is any kind of fund transfers which is suspicious. So these kind of factors SEBI takes into consideration while making a case of fraud, and it is very important. So there are different pieces of a puzzle. When put together, they say that these are the factors which says, because at SEBI, in fact, an inference or a circumstantial evidence or preponderance of probability also, they can charge anybody with fraud. But it is advisable for such person to go for proper legal advice, because there are nuances with respect to these connections and the whether there is any meeting of minds or not, whether there is any analysis, whether there is any price volume impact due to their acts on object. It has to be critically analyzed. Then one of the most important factor which is there is whether there was any basic economic sense while trading in the securities market. For example, if a buyer is placing a order at a higher price and a seller is placing order at a lower price, it defeats the basic economics of a trade, of a transaction, because a buyer would not want to pay a higher price, and a seller would not to get a lower price for its security if it is available in the market at a higher price. So these kind of tests which SEBI generally does. So going forward, I would like Ankita to throw light on these. So I have given a broad perspective how the SEBI, what are the recent trends and what have SEBI done in the past while investigating the matter. So my colleague Ankita would throw light that what is the at the back end, how does SEBI and exchanges and the regulator actually carry out the surveillance and investigation.
Thank you, Nikita, for sharing your thoughts upon this. Taking forward, it can be affirmatively said that the number of frauds in the security markets have been increasing in recent years, and this is due to increasing sophistication of technology and growing use of electronic trading platforms. And they are being more complex and difficult to detect, investigate, and enforce. To negate the threats posed by these frauds, SEBI, the apex regulatory body of the stock market in India, has been trying to swiftly pursue to catch its prey. by incorporating effective controls around their processes. SEBI's regulatory framework is comprised of three components. Basically, these three components are surveillance, inspection, investigation, and enforcement. And each of these components are characterized by distinct processes and tools. The first leg is that of surveillance. SEBI uses a multifaceted approach to detect fraud and market manipulation in the securities market. The surveillance process involves the following steps. So basically, it collects the trading data from various sources such as stock exchanges, depositories, and other market intermediaries. After collecting the data, it is analyzed. Sophisticated algorithms and statistical models are used to analyze, and if it reveals any suspicious activity, an alert is generated and sent to SEBI's investigation and enforcement teams for further scrutiny. SEBI has devised a policy framework to govern all the market participants. So basically, we can say broadly, there are three market participants: issuers, intermediaries, and investors. For issuers, the policy framework looks like LODR 2015, Issue of Capital and Disclosure Requirements 2019. For intermediaries, we have intermediary regulations, stockbroker and sub-broker regulations, and of course, FUTP regulations 2003. For investors, we have policy frameworks like Foreign Portfolio Investor Regulations 2014, AI Regulation 2012, and the number can continue. There are many surveillance measures, tools taken by the board to quote some. So surveillance measures, there are multiple tools that SEBI uses. But to quote some, we will be quoting tools like additional surveillance measure. So in additional surveillance measure, the focus is on controlling security volatility. It checks the unexpected price movement in a stock and controls malpractices, also the speculative activities. So the ASM, additional surveillance measures, is done using two things. First is circuit filter, which can be by 5%, and another is 100% margin on open positions in the stock. Usually, the brokers are expected to keep a margin of 35 to 40%. So by having 100% margin, the margin trading are disabled for these stocks. Another tool for the surveillance that is used by SEBI is graded surveillance measure. In GSM, the premise is to safeguard the interest of investors by developing preemptive surveillance measures. This includes to monitor securities with unusual price fluctuations or poor financial health. Primary object is to alert and advise the investors to be extra cautious while dealing with GSM securities. Those companies that come under the market are usually known as penny stocks. So mostly in GSM, you'll find penny stocks that usually have a poor performance. And in most cases, these securities are subject to financial misconduct. These shares are usually monitored for sudden changes in earnings, book value, net worth, and so on. So intraday trade is not allowed for the GSM graded securities. Other tool that is used by SEBI for surveillance purposes is caution against unsolicited SMSs, also rumor verification and clarification in case of spurt in price or volume. So here what SEBI does is SEBI seeks a clarification from the company, and those clarifications are posted on exchange website so that the rumor that has been spread can be taken care of. So what is the importance of surveillance system? This can be seen by the multiple plethora of cases that have been there. For example, Kavi stock broking case 2019, where SEBI conducted surveillance on the Kavi stock broking and found that it had misused clients' securities to raise funds for its own use. And there are multiple cases. If SEBI believes that something is fishy during the surveillance process, it moves it to next step, that is inspection and investigation. The purpose of inspection and investigation is to thwart financial frauds in the securities market. Inspection. SEBI is empowered to conduct inspection of registered intermediaries. So inspection is done broadly under three scenarios. The first is as a matter of routine activity. Second is to ensure compliance with the provisions of law. And is third when it receives a complaint from investors or any other source. The procedure of inspection involves the following process. So basically WTM authorizes inspection and WTM only appoints inspection officer. In case of routine inspections, prior notice is always given. However, regulations entitle the inspecting officer to waive the requirement of prior notice. Inspection officer may take the help of outside professional independent auditors during the inspection. For example, in Big Fours, EYs are engaged for conducting forensics. SEBI forwarded the inspection report to the intermediary for its comments on alleged violations before initiating disciplinary proceedings. Based on written and oral submissions, WTM decides the steps and actions that needs to be taken on the inspection process. Intermediaries and their employees are under a statutory obligation to cooperate. Chapter 3 of PFUTP regulations deals with the investigation processes. It gives powers to SEBI to initiate an investigation if it has reasonable ground to believe that transaction securities are being dealt in a manner that is detrimental to the securities market or to the investors. So Section 5 of PFUTP grants the following powers to the investigating authority. So investigating authority, the WTM formally appoints an investigating officer, and the investigating officer can call for its information or records from any person. It can undertake inspection of any book, register, or other documents of any listed or a public company. Investigating authority can keep these records for a maximum period of 6 months. And of course, it can call these records again whenever it wants to. It also examines orally and records the statements that can be used as a piece of information, as a piece of evidence against such person. It can also conduct a search of premises and seize book and registers. But before this, they need authority appropriate orders from the judicial magistrate. Based upon these, investigating authority prepares either an interim report or a final report, which is analyzed by an internal committee of senior officers of SEBI. So when internal committee of senior officers analyzes the report, once it's analyzed, it is sent to the WTM. And WTM decides what further course of action needs to be taken on it. When SEBI is doing its investigation, it is bound by some procedural obligations. For example, it is, and in the procedural obligations, it is guided by sections like 11C and 15I of the SEBI Act. So what all it needs to do is that it needs to send a show cause notice to the party being investigated before taking any actions against it. So the basic principle behind is that the investigated party should get an opportunity to provide its defense. Also, the investigating party needs to show, and the show cause notice that is given to the investigated party must be accompanied by the reasons and proofs for conducting such investigation. The documents should be, we can say that the document should be in proper picture. The investigating officer can order for the production of documents. It can summon for the presence and opportunity to investigated party to reasonably present its defense. So these are the powers that are enjoyed by the investigated officer. There are also some rights and duties that are enjoyed by the investigated party. Those rights and duties are like that there's a duty to cooperate. When the investigating officer summons to produce some documents or summons to appear personally, then the investigated party needs to cooperate. And it has to appear before investigating officer whenever required to do so. Allow the investigating authority to have access to the premises at all reasonable times. It can seek information documents relied upon for SCN investigation, SCN or the investigation report. Can seek the opportunity to orally present the case and defend its case. Can seek time to prepare written submissions and documents. And multiple times people are confused at what are the consequences if we do not cooperate or we try to conceal or present the wrong information to the SEBI. So the consequences for non-cooperation is that the SEBI investigation can have serious consequences, including legal action, penalties, loss of license, damage to reputation, and of course, adverse market impact. When someone tries to provide wrong or incomplete information, SEBI can impose a penalty up to 25 crores or 3 times the number of profits made by the investigated person. And the other legal actions which can be followed can be fines, imprisonment, or both. And of course, loss of license, damage to reputation, adverse market impact. The investigated party has the right to defend themselves. This does not entitle them to conceal facts or obstruct the investigating authority. The next and the final step in the regulatory process is enforcement. Enforcement is a process where actions taken based on the findings of the inspection and investigation are taken. If evidence is of misdemeanor is found, SEBI initiates disciplinary action using its quasi-judicial authority. In case it can issue orders or directions. The orders or directions can be for suspending or cancelling certificate of registration of the intermediary or the stockbroker. It can also impose monetary penalty. It can restrain a person from accessing the securities market. These can even be issued without giving an opportunity for a hearing, provided that a post-decisional opportunity of a hearing is given. Initiate criminal proceedings by filing a criminal complaint before the Sessions Court. So all our orders passed by SEBI are reasoned orders. What do we mean by reasoned orders? Each order is self-sufficient, contains facts and rationale before it is disseminated to the public. Once the enforcement functions of SEBI are complete, the aggrieved person, if the person feels that it's aggrieved, can appeal to the Securities Appellate Tribunal against any order passed by SEBI. So to end, the entire process is governed by the principles of natural justice, procedural fairness, and democratic governance. There is absence of biasness, and ample opportunity is provided to the aggrieved person to defend itself. However, some improvements are desired, which will be elaborated by my mentor and senior, Ravi sir. Ravi sir, to you.
Thank you, Ankita and Nikita, for giving a very wonderful heads up on the program. Before coming to suggesting the measures, but I hope I'm audible. Am I? Okay.
Yes, you're audible. Can you carry on?
Before coming to the suggestive measures that can be made to SEBI, although I must concede in all fairness that it is one of those regulators, and I'm not talking about Indian context, but the global context, which really listens and takes improvement and implements steps which will lead to improvement in their processes and measures that they take. And what I'm going to embark upon today would reflect that how SEBI has evolved as a regulator, not only of the might in its name, but also the might of its character. And that is the story of SEBI. And this story has developed because SEBI has thwarted and dealt with so many cases of fraud, so many novel concepts and novel designs and schemes applied by individuals and entities at different point in time. And at some time, SEBI has to deal with all these issues together. But nevertheless, SEBI has always tried to take it up, although howsoever challenging it is. And as Sir also said in his plenary remarks, that now that SEBI has automatized a lot of procedural requirements, and that being an ongoing process which is running at a very fast pace, SEBI's focus on this aspect of the market, which is the fraudulent and unfair trade practices in the market, is going to be eagle-eyed. And SEBI is going to take these issues by its horns. And we will be seeing in this decade, and I say so because there are a lot of issues which are open and gray. At least in my opinion, I can call them open and gray. But we will be seeing a lot of those issues being settled by the courts because, the interpretation, as Justice Cardozo said in one of his opinions, that interpretative exercise is both of legislative character and judicious character. Judicious because courts are bound to interpret, and they are the only one who possess the authority to interpret the legislations. And why does it have a legislative effect? Because the principles laid down by the courts have a binding precedential value. So it is both a legislative and judicious exercise. Now, coming on to the, much has been said and the definition has been quoted, what fraud is, how SEBI has legislated it, how it operates. But there are a couple of developments, both international and Indian. Let me come to those developments and then we will take it piece by piece. Some aspects that Nikita has captured, some of them have been captured by Ankita. And I would request my colleagues to be with me in this interactive discussion. So you see, the case of Kanhaiyalal Baldevbhai Patel, it is not one of the cases, it is not the only case which went till Supreme Court for deciding these contentious issues. There is Kishore R. Ajmera and Rakhi Trading is there. Then there is a case of Bhavish Pabari. All these cases where these contentious issues were raised time and again. And much in past, there were Ketan Parikh's case and multiple cases that went to the court for decision on the principle. In Kanhaiyalal Baldevbhai Patel case, Justice Gogoi, back then the former Chief Justice of India, he said in para 6 of his judgment, the definition of fraud, which is an inclusive definition and therefore has to be understood to be broad and expansive, contemplates even an action or omission as may be committed, even without any deceit, if such an action or omission has the effect of inducing another person to deal in securities. The emphasis is on the act of inducement, and the scrutiny must, therefore, be on the meaning that must be attributed to the word induce. So a altogether different test was propounded by Supreme Court. They said, forget about nitpicking and looking into each and every word and going for the etymological test and digging deep into the words, reading between the lines. Here is the principle where the fraud has been defined in a catch-all phrase. There is one definition which can be called inclusive, but this is not inclusive. This is on a pedestal higher than an inclusive definition. This is called catch-all. Whatever is written, it catches everything, all and sundry, everything under the sun. So this is a catch-all provision. A catch-all provision is easy to legislate because you do not need to apply a lot of mind in legislating it. You keep it broad, you keep it fundamental. The problem arises when you go to enforce it, because then how do you make principled distinctions between situation A and situation B and millions of other situations that can be expounded based on the same definition? So what is lacking is the basis for a principled distinction. The law is right, the law is correct, this is how it is ought to be. In Indian context, we have seen that the legislative exercise is sometimes, it is called reactive, but in securities market, and I was discussing it with one of my seniors, Mr. Ankit Singhi, in a casual discussion one day, and I said that why do we legislate reactively? He said, what else you do in a market which is so dynamic and ever changing? You must do reactive legislation, because if you do not react, things may become drastically wrong. So one part is that reactive legislation. So I'm not advocating that reactive legislation is bad. Reactive legislation might be necessary given the practical considerations. The real problem lies into the enforcement and implementation of these regulations, not because of their inherent weakness, because of the difficulties that it poses to the courts and to the regulator itself in making a principled distinction. What could be fraudulent? How do you prove inducement? There are no thumb rule tests for these things. It has to be collected based on entirety of surrounding circumstances and the facts and the connections, as Nikita and Ankita embarked upon, how the connections are drawn by SEBI. But let me tell you something more interesting here. Nikita took up a point where she said that in Indian context, the test is of negligent standard, which practically would mean that any tortuous act even a tort might attract the charges of fraud, even though there is no dishonest intention or intention of deceit. That is true, partly, because the law has evolved and it is changing. In United States, as she mentioned, yes, there is a judgment, and there are a couple of judgments on that aspect that, without dishonesty, without the element of deceit, you can't really charge everyone under these provisions which deals with fraud. And because we know that in USA, the Bill of Rights, which is also known as the Chapter of Fundamental Rights in our Constitution, is much mature. So they weigh the public importance as well as individual liberties in a different context. In Indian situation, I'm not saying that gap is huge, but there is a discernible gap. So as to say we are more Benthamite or more utilitarian when it comes to pairing two objectives. One of the objective which serves to the larger public good is given a go ahead, and even at the cost of a lesser objective, howsoever benign it is. So that is one part. But the controversy now is that whether in Indian context, anything, any wrong, any error can lead to the charges of fraudulent and unfair trade practices or not. I feel no. And there is a basis for it. In 2018, the FUTP regulation, which is a 3-tier regulation, there are 3 chapters. One deals with the definition, second provides with the substantive provisions on what constitutes as fraud, and the third chapter, it provides for the procedure of investigations and the process to be followed to implement it. But in 2018, in chapter 3, that deals with the substantive provisions of the law of this regulation, an amendment was made, and a word knowingly was added. So therefore, and this amendment is of 2018. The Kanhaiyalal Baldev Bhai Patel's case is of 2017. And there is another case which is less talked about, which is Pyramid Saimara Theatres, which is of 2010. What was said in Kanhaiyalal Baldev Bhai Patel was said by SAT in a different language. It was couched in different language, but the principle was analogous. SAT said that no, nothing doing. You need not to test mens rea or dishonest intention to determine whether there is a fraud or not. Or you do not even need to determine, later decisions said that you do not even need to determine whether there is a loss or gain. Forget about it. If someone tried to defraud the market, that attempt is itself punishable. Why not to punish it? Why to wait and suffer a real damage before taking an action? So they said that these principles were upheld. Kanhaiyalal Baldev Bhai Patel is the judgment which cemented all of this because it came from the apex court of the country. And as per Article 141, it is the law of the land. Article 141 of the Indian Constitution, just for the records. Now, the difficulty is that in 2018, right after the Kanhaiyalal's judgment, the amendment added the word knowingly. What is the effect of this word? The effect is that whatever is being done, the definition remains same, but for the addition of this word knowingly. But this word makes all the difference. And the difference is that an unintentional or a bona fide error, or an error that has been made in good faith, or an error which is not knowingly made, because in fraud there could be multiple parties. A company, a merchant banker, RTA, professionals, many people could be involved. And as you have seen in the cases, you see the cases, so the case of PwC, they were the auditors and they were charged. So the element of knowingly is a good development and it's a good addition. And this follows the case of the case which Nikita mentioned, which is of Ernst & Young, I believe, from United States Court.
Yeah.
And after that decision, SEBI has amended and added this word knowingly. So after 2018, and as we talk now, merely because an act has been done, they cannot simply punish it by calling it fraudulent, because the element of knowledge is added, is provided for in the law. So far as the negligent standard test is concerned, a question might be arising in your mind that what happened or what became of that test. Now, whether that test is useless, I say no, that test is not useless. Because you see, the securities adjudication or investigation or enforcement, apart from surveillance is a bird of different flock and feather. It's a non-invasive exercise. Although there are different school of thoughts on whether surveillance is non-invasive, surveillance by SEBI is non-invasive, or it is also invasive. But that is a talk of later day. Today, we are focusing on all these enforcement actions, which have different manifestation, adjudication, inquiry, the measures under Section 11, and so on and so forth. By whatever name they are called, the effect is that they do affect the rights and liberties and of people on whom they are imposed, and they also tend to regulate the market in some way or other, and they set a precedential value. So these are not merely administrative order issued to the all, but they are to specific persons or group of persons. So that is enforcement. In enforcement, the negligent standard test works as a core and penumbra. So the core is that you satisfy a case of fraud on the scheme of the regulations that is laid down. And the penumbra is, understand it as a periphery. In the core is the scheme of the legislation, and in the periphery is the conduct of the person. So the negligent conduct standard or the negligent standard test is essentially checking whether a person who is subjected to any investigation or who is being tested of his conduct in the market at the relevant time or at the particular point in time when the SEBI is alleging a charge on him that he acted fraudulently, whether that person was acting as a reasonably prudent man or not. If the person was not acting as a reasonably prudent man, which is also called, the negligent standard test is also called reasonable standard test. So if the person is found to be not acting in sync with the standard of a reasonable man, then it provides an indication that this person was involved in something unusual, which is not expected out of an ordinary market participant. Now, why there is a need of so many tests if the word knowingly has been added in the law? And I'm sure the moment I ask this question to myself, you must have thought about an answer regarding this. And the answer is that the knowledge is personal and remains within the memory of the individual. The knowledge sometimes might be reduced to a paper in writing or in an electronic device. You can find the knowledge through call data records or by intercepting the calls, which power SEBI does not possess today, although it was recommended by T.K. Vishwanathan's committee report back in, I think 5 years back from today. But that power is not there, although the Central Board of Taxes has got that kind of a power. But the point is that knowledge can reflect from something which is documentary. A document, as you would know, could be electronic, could be physical, could be so yes, basically there are two categories. It could be electronic, physical, and the new thing is cloud-based, which will also fall within the ambit of electronic evidences or electronic documents. But the point here is that in each of the cases, and in each and every case, you would not recover these documentary evidences. And this trouble was recognized by Supreme Court of India. The matter reached till Supreme Court of India in a front-running case. And that was the case of Kishore R. Ajmera. I'm talking about 2016 and 17. So in this case, there is a specific remark of the judgment. It's a beautifully written judgment by Supreme Court. And in that judgment, they have said that, and I'm not quoting it from the judgment directly, but I'm giving you a broad sense in a much simplified language, is that they found that so the question before them was that there is no evidence, but SEBI had applied these circumstantial evidentiary tests and brought up before the court certain material which would showcase that the person was not doing the right kind of thing which is expected of a person dealing in securities market. But the question in defense was that where is the evidence? This does not tantamount to be an evidence. The court posed a pointed question to the counsels. They said, what should we do then? Should we leave SEBI toothless? Because seldom, it is not a murder case where you would recover weapon or blood stains or dead body. No. It's a case in a market which is moving very swiftly. And clinching evidence in most of the cases is very hard to get. SEBI might get to investigate the matter much later in the day when the alert is received or when a complaint is received in the matter. So what should we do then? Should we let go culprits scot-free? And then they pronounced the famous test of preponderance of probabilities. It was in Kishore R. Ajmera's case that I recall. Before that, I do not recall of seeing any literature specifically to the securities law regime where this preponderance test was elaborated as was elaborated in this Ajmera's case. So the Ajmera's case for the first time said that this is the preponderance of probability and you test it on basis of the preponderance of probabilities. What does this mean? Preponderance of probability mean that you connect each and every circumstance which can reasonably be connected with the cause of action and see whether it is giving a picture of guilty or it is showing innocence. If the picture is of guilty, you need to see whether the guilt is absolute in the sense, not absolute as in the case of documentary evidence, but whether there can be any other possible hypothesis or any other possible story by the person or by anyone which would prove the innocence of this person, or any other possible hypothesis is probable in this case or not. So that is why the test is called preponderance of probability. The word itself tells that the probabilities are tilted and tilted greatly on one section or another, towards the guilt or towards not guilt. Now, why I gave you all these examples before coming to the core of the matter is that these positions are cemented today. So today, and after 2018, there is another amendment, which was of 2020. And that amendment gave the power to SEBI to even look into maligned financial statements wherein the fraud is done by cooking up the financial statements. So that kind of fraud is also in the domain of SEBI. And by my first-hand experience, and as I speak, there are many companies which are receiving notices from either exchanges or SEBI to explain their entries and their accounting treatment of the numbers in their books. And why did they particularly treat a particular amount, or they categorized a particular amount under a particular head? And why did they write off a loan within so and so period, and what is the reason? And all kind of queries are rising, and that's very interesting because we thought SEBI is only a regulator which focuses on the markets, but the way they have picked up on their financial on the financial side of the law is also commendable. Now, so far as the investigation or the charges of FUTP are concerned, it usually starts with surveillance, as Ankita told. Surveillance then results into red flags, alerts. Sometimes SEBI also receives some complaints and they decide to investigate the matter. Investigation, you see, is an invasive process, and there is unanimity across the host of experts that investigation is a invasive process. What do I mean by invasive process? Invasive process means that if I am being investigated by SEBI, somewhere my liberties will be crippled or somewhere my day-to-day life would be affected because I am under obligation to attend to SEBI's summon. I have to provide them information. I have to cooperate, attend, and they can come. All of these things. So this is why this is invasive. Surveillance is not invasive because most of the homework SEBI does it in its own office or through the outsourced experts. But as my first-hand experience goes, that SEBI has got capabilities to process the data and do it in-house only. So that is not invasive. They don't come to you when they are doing surveillance. You are affected only once the investigation is started. Now, investigation usually starts with an informal email that might come to someone in their inbox from SEBI seeking certain information. Some people have some doubts on, and this is out of my first-hand experience that, and it was a very valid query when I looked at it in past, when it was raised to me for the first time. So the question was that whether email which is received from SEBI seeking information, is it mandatory to reply to such email? Or should we wait for the summons? Ordinarily, one should not wait for the summons. The moment you receive an email from SEBI, and if there are doubts on whether this email is from SEBI or not, one may ask it politely to the regulator or by replying that and may ask for authority or maybe some identification proof, but that must be done in a polite way and must be willing to cooperate since the beginning. There must not be any attempt to delay or derail the investigation because, in my frank opinion, one cannot do it. That's an unachievable objective and target. First of all, if a person has done something wrong, delaying or derailing or interfering with investigation will not bring only one charge. It will bring an additional charge of non-cooperation or suppression of material. As I told, the preponderance of probabilities. Now, just imagine when the court would be testing a conduct of a person, and I told you, conduct should be reasonable and it should not be negligible. And probabilities has to be prepondered. A person who did not reply to SEBI, did not give any information, provided false information, tried to outsmart SEBI. What do you think? Even in absence of any evidence, which directly, or a clinching evidence which directly says that he is the fraud or manipulator, these are the circumstances which can be considered as an evidence indicating towards the fraud or unfair trade practice or market abuse. So this is absolutely not advisable. One must not resort to these kind of dilatory tactics, especially with SEBI. Secondly, it is important that one is aware of their rights. Seeking, when at the summoning stage, you may always seek a clarification if a question is not clear. You may always seek a clarification from SEBI. If a particular day has been appointed for recording the statement and there is a genuine difficulty due to any emergency or otherwise, or a business difficulty, suppose it's a closing day or there is some very important event which was not envisaged and it occurred, timely informing the SEBI and requesting for time, they also allow. It is not that one should be non-responsive and non-attending to the summons. Thirdly is that whatever information is asked by SEBI in summons, it is the duty of the person to supply it. But as I said, it is coupled with the right that you must first understand the information, what is being asked from you. Later on, after the summoning part, which more or less involves given the data in writing, there comes the statement recording part. That is also part of the investigative process. And I'm not focusing on the investigation, but on the FUTP part. In investigation also, the state recording of statement, one must bear in mind that lying or giving incorrect information, inaccurate information to SEBI while recording of statement may also be held against a person who's making such statement. And this is true in many insider cases. Many insider trading cases, especially in United States, where people were giving testimony to the commissioners or the officers appointed by SEC. When they lied on a particular question posed by SEC, that was clearly taken as an evidence against them and used for taking adverse inference against them. And then they were punished. So lying is not an option. Now, after the investigation is culminated and a show cause notice is received, howsoever depressing the case appears, one must always look for the information and documents accompanying the show cause notice, or that the documents and information that have been relied in the show cause notice that you are expected to meet. And on this particular aspect also, there are a lot of case laws which have now been developed. The old case laws, I mean, the one of the oldest case laws on the point of supplying of information, duty of SEBI to supply the information, a right of people to receive the information from authorities. Although the case I'm going to cite is not from the securities law regime. It is the case of KC Tandon versus Union of India, rendered by Supreme Court in 1974. Thereafter, Kashinath Dikshit and Natwar Singh case, which Natwar Singh case was for ED for some FEMA provision, but was followed by SEBI until it was distinguished and a new and a fresh thought of fresh thought was infused by Justice Chandrachud, the current Chief Justice of India, who rendered the decision in the case of T. Takano. And he focused on two aspects. He focused on the aspect of transparency and reliability. To sum it up very quickly, he said that, see, if the procedure is transparent, if the procedure is scientific, if the procedure does not furthers opaqueness, if you don't keep the noticee under blind eye, the reliability of the outcome will increase, and that will help in cutting costs, cutting litigations, and delays in culminating matter and delivering of justice. Because in securities market, as the market is very fast, the justice delivery system should also be sped up. Now, this was about supplying of information. A lot of times the challenge arises is that you ask a document and you find that it is not being supplied because of the fact that it is not relied upon by SEBI. And a lot of times I'm being told that this kind of a response is received, that a document is not relied and therefore it is not being supplied. Here is also a difference between, if you compare the Indian jurisprudence and international jurisprudence, the difference is that while in India, the fact that the document was not relied upon could be an arguable, could be an argument in the court to not supply it, to not disclose it. In international context, this is not a difference. The only difference is if the document, the disclosure of document is protected by the privileges laid down under the laws, or the privileges that the authority otherwise commands, that the privilege is that some information I want from SEBI in a case, but that information, if disclosed, would pose a threat to the integrity of securities market, or it will divulge some confidential information about the third party, maybe some big conglomerate, they will not share. These are the privileges. Apart from this, in international context, there is no other excuse. They say, if you have used it, maybe you relied on it for issuing the final notice or not, but if you have used it, if this was in any case used, you disclose. And I remember one Supreme Court judgment which says this, again in simple words I'm trying to put, that the human mind does not function in compartments. When it receives impressions from different sources, It is the totality of impressions that go into making the decision. It is not possible to analyze and dissect the impressions and predicate which impressions went into the making of decision and which did not. Nor is it an easy exercise to erase the impression created by particular circumstances to exclude such an impression's influence in the decision-making process. Therefore, for a quasi-judicial authority, all the relevant information must be disclosed. That is one of the, I just read out an excerpt, not quoting it, but in a simplified version. This was that once you see a material, your mind consumes it and you can't delete it. It will always have some effect on your judgment, on your decision. So that requires disclosure of all documents, but T. Takano, it says that if it is not relied on, it is not necessary, but that's not the absolute law. T. Takano also has made the Indian and international jurisprudence somewhere perimeteria in saying that if it is excluded by privileges, need not to give it. But in other situations, transparency, the objective, the focus was on achieving the transparency and raising the bar of transparency in the proceedings so as to ensure the reliability of outcomes. So this was so far as investigation is concerned. Now, coming back to the core part of the regulations, when you have to mete out the punishments. The punishment, the measures under FUTP regulations usually do not, in many cases, or I mean, I'm not saying it statistically, that whether these kind of cases are many and the other type of cases are less, but there are substantial number of cases wherein when fraught with a situation of fraud or market abuse, the first reaction from the regulator is that it pulls out an arrow from its quiver, and that arrow is called Section 11 order. It's an ex parte ad interim order, which bans you, which may also direct for disgorgement of gains. And that order, and for good reasons, that order is in form of a show cause notice. So the principles of natural justice, they are not rigid. I mean, this has been held by courts now that those are not inflexible, rigid principles. Those are dynamic principles. And it is possible to comply with principles of natural justice by giving a post-decisional hearing, which happens in cases of ad interim ex parte orders. So the order is treated as show cause notice, time is given, a reply can be made to SEBI. Now, it is very important for those who have to defend those cases, or from an academic perspective completely. It is very important that the work done by SEBI is scrutinized. And this is not to hide something wrong that has been committed. This is very imperative because a decision, if wrongly taken, may cripple individual liberties. And more than that, not talking of an individual's case, more than that, it will set a bad precedent. So for the sake of good development of law, cases where one feels that some error has been crept in, or the name has been pulled out or roped in or arrayed in a case of market abuse or fraud by an error, or probably due to the technological system's incapability of sifting the grain from the chaff. One must scrutinize, check the veracity, avail all the information, do a holistic study, and then make a representation to SEBI, assisting SEBI to look at different nuances, different angles and aspects of the matter, so as to give a reflection of their innocence. Moving ahead from this, I mean, there is one point which would clarify this. There are many cases in which decisions were reversed, in fact. And in many cases, although the main culprits were punished, along with the main culprits, some small fishes and some genuine investors were also got trapped into the net of surveillance, investigation, and the process, the legal process. Now, lawmaker cannot tell about each and every remote possibilities. Where the work of lawmaker ends, the work of courts start. So in those cases, only because scrutiny of SEBI's work was meticulous, and they were able to showcase on the theory of preponderance that a probable or that a more plausible hypothesis was present, they got a relief. And there have been plethora of such cases. I'm not saying that that the main culprits got scot-free. No, technical arguments are of no avail for people whose hands are stained. But genuine people, genuine investors who get embroiled due to the legal system, due to the functioning of the legal system, they always have the safeguards, and those safeguards are enunciated in Article 14 of Constitution, in the SEBI regulations as well. And they can avail, and they have the remedies also, remedy of appealing to SAT, going to the courts, and they must defend, they must present, and I would not say defend, they must assist SEBI in sifting the grain from the chaff. So that is all. That's all from my side. I believe it's a vast topic, but before parting away, I would like to say, as Mr. Janak Dwarkadas, I heard him saying this. He was instructing one of his junior, and later on he was also addressing a public seminar where he said this. He said this: see, a lawyer's work, 90% of a lawyer's work is done inside the chambers. It is only the 10% which people see in the courtroom. Also, similarly, 90% of the SEBI's work is done beyond the reports that are the orders that are published. So what lies hidden, one must endeavor to ask and scrutinize and assist SEBI and point out if they have gone on a wrong direction in an individual's case, or is there any other way to look at it? That's all.
Okay, thank you, Ravi, Nikita, and Ankita. You people have covered the legal aspects, the aspects of investigation, and what types of fraud is taking place. Friends, this topic is very big, and you cannot summarize it like this, because every time there are so many types of things and there are so many issues. So we organize this program for this basis to give it's just like an index type of program. In future program, we will cover the case studies, how this is happening, so people will understand. Now, there are few questions which are there. Let me just ask. Ravi, tell me, what is this front running and insider trading? How this is different?
Well, there are blurred lines between these two concepts. I would try and explain front running first. Front running is usually when an intermediary or a person who's dealing in securities is using their prowess or their influence on others to take some positions in that particular script, or in the scripts where the person who's making the solicitations is himself more interested. So usually if I have shares of X company, I would tell others to buy more and more shares of X company. Price will go up and then I will sell and exit. And the poor, hapless investors will be stuck with their loss-making investments. This is the classic case of front running. Front running may also manifest in different forms and different ways. It's a very nuanced concept. It could also be that you are doing cherry picking. Cherry picking means you are leading your one client and leaving behind your another client. That's a front running by cherry picking. But broadly, the concept is this.
Okay. Can FUTP are settleable with SEBI?
Only if they do not have market-wide impact.
Okay. What is synchronized trading? And what are the different forms of synchronized trading?
Well, synchronized trading is when, although trading on an anonymous system, you game the game the counterparty or game the system itself, game the participants, and you do 1, 2, 3 and put the bid and put the ask. So the system matches it. So the 1, 2, 3 trading, as you have explained it in a very simplified way in previous webinars, that is synchronized. Synchronized means you do reversal, you do self trades, you do circular trades. But here is something very important. In case of Ketan Parekh, as well as Shubhkam Securities, SAT has held that in synchronized trading cases, merely because trades are synchronized, they are not per se illegal. For self-trade also, there is a judgment that self-trades are not per se illegal. Intention has to be proved.
So what are the legal factors which decide legality of synchronized trading?
See, synchronized trading is that they will, or for any case in securities market which is charged with the allegation of fraud, one needs to prove that the conduct was bona fide, the objective was bona fide, and it was an economic decision taken with the commercial wisdom. If these three things can be proven, I think most of the charges gets diluted.
Okay. You have mentioned the investigation should be there. If there's no cooperation in investigating the authorities, then what is the consequence?
So the first consequence, which many people do not see or many people do not perceive, is that non-cooperating in investigation may give some adverse inference against the person in the case itself. Suppose it's an insider trading case and the person is asked to respond on few questions. He stays silent. He stays non-cooperative. It can be presumed that he's the person, he's running away, so he's the person who has done it. And apart from it, he'll be charged for non-cooperation as well.
Okay. Can FUTP insider case be settled at a pre-SCN stage?
Yes, it can be. But it can't be settled if the investigation is ongoing. If the investigation is completed and SCN has not been issued, between this period, one can settle it.
But charge is not framed, then how can I settle?
So in settlement, there is an option of filing a voluntary settlement. And there in that process, based on the disclosures you make and the decision and the scrutiny of examination by the internal committee, they decide what all charges are applicable or attracted to the case. And then they decide the settlement amount.
Okay. SEBI has a power of search and seizure that is there. But SEBI has a power of search and seizure, the same power which income tax and other regulatory authorities has?
Yes.
Whether SEBI has a power to arrest?
Well, that is a tricky question, not directly, but yes, they can seek cooperation and arrest.
Okay. If the trading was done by entities that are subsequently merged, will the liability of such trading will be transferred?
Yes, due to merger. If it is a corporate entity, yes, the liability will shift due to the doctrine of merger and amalgamation.
Okay. There are any limitation or investigation power of SEBI?
There is no limitation on the time period, but there are judicial tests. So if a matter is, and again, that test works on the availability of evidence. So if the time lapsed is extraordinary, which is called as inordinate in the legal sense, and the time lapsed is of such nature that the noticee cannot prove by way of a positive evidence his innocence or her innocence, and it is on record that SEBI was apprised of the matter long back in past and still they did not take any active steps to conclude the matter, certainly, yes, there are many judgments, there are many orders. I think Shruti Vora was one of the cases where they put up this issue and SAT rejected. SAT then you can't proceed now.
Okay, legal remedies available against SEBI's order?
One can go to SAT. That's the legal right. That's the statutory right of appeal. That's the first appeal. And beautiful thing is that before SAT, both the questions of law as well as of facts can be taken. And there is a judgment by Supreme Court in the case of Balram Garg versus SEBI, which is known as PC Jewelers case. There, the duties of first appellate court is laid down in detail. So the Supreme Court has laid down at one place as a compendium that what is the duty of the court who is listening the first appeal from an order of authority.
Okay. So appeal to SAT is going, you can appeal only in Supreme Court. Is it right?
Yes.
But some cases, the High Court is also passing an order.
Yes, that's a $1 million question. And that's perhaps more nuanced a subject or topic. See, there are two kinds of orders that SEBI can pass. And there are three pillars of SEBI's functioning or limbs. One is legislative, second is executive, and third is quasi-judicial or judicial. So far as the legislative wing is concerned or the executive wing is concerned, these two matters can be challenged in high courts. In judicial decisions, in exceptional cases where the constitutional rights of a person is at stake, one can go to high court, but courts say that you have an alternate remedy, you go to SAT and then come back to us. Unless until the case is of a manifest arbitrariness, high courts usually do not interfere. But if it's an administrative circular, suppose a circular is issued under Section 11 to all the brokers, to all the intermediaries and stock exchanges to comply with a particular norm. And if someone finds that circular is unconstitutional, one can go to high court and challenge it. And that is a decision rendered by Supreme Court on NSDL versus SEBI. And there was another appeal, CDSL versus SEBI, rendered by Rohinton Fallinariman, Justice Rohinton Fallinariman.
Okay. Whether SEBI has power to initiate multiple investigations on the same subject matter?
No. SAT has rendered a decision that res judicata is applicable on SEBI as well.
No,
But in one recent case, SAT has said that if the violations are different, same cause
Yes,
of
of
action
course.
is resulting in
Of
different
course.
violations, then they can investigate multiple.
But I think the question is if the subject matter is same or the entity is same. Same subject matter. No, same subject matter, there cannot be two investigations.
Yeah, same subject they cannot.
They are passing 11B order and sometimes they are passing adjudication order.
That
is going on.
That is going on, sir. And despite there being a lot of moral criticism on this approach, that is practically required also.
Okay. Can SEBI refer the case to other regulatory authorities? Certainly,
sir. Yes.
If the company is allies with the charge of fraud, can director also be charged with the fraud?
Yes. If the complicity is evidenced and the rule of lifting of corporate veil says so, because the company does not have its mind of own. So if any fraud has been done, it has been done through directors or some officer, some individual who was operating the company or controlling the company.
Okay. How do you foresee a compliance officer to ensure that FUTP is not being carried out within the organization?
Another interesting question. So a compliance officer must know that insider trading, every insider trading case is an
unfair trade practice.
Yes. So every insider trading case is an unfair trade practice. There are two keywords in FUTP regulation. One is fraudulent and another is unfair. Every fraudulent trade practice is not insider, but every insider trade practice is unfair, because unfairness is that some information which others do not have and you have, you deal on basis of that information. That is the unfair element of that trade. So a compliance officer must follow the compliances laid down under LODR and the host of SEBI regulations, must also scrupulously comply with the insider trading regulations. Apart from that, compliance officer has got no investigative powers, nor there is such any duty to investigate the kind of fraud SEBI investigates. So the duty does not go that far. But so far as the compliances are concerned, he must be scrupulously observing the compliances.
Okay. But question is, the compliance officer, how he will ensure? Because he cannot track everything. Insider trading, there is a system that you have you can ask the compliance officer for trade, contract trade, other things. So many things are there. But FUTP is not in his control.
Certainly, sir. FUTP is not in his control. So the fraud part is not in his control. Unfair trade practice, so far as it is pertaining to the limited realm of insider, he can have a role to play to curb it.
Okay. So thank you, Ravi and Nikita and Ankita for giving answer. Anybody has any other question, you please send it to us. Now, before closing today's session, I have certain suggestions which I think you people can vote down and we can elaborate and send it to SEBI, because working in the capital market for last 25 and 30 years, I have seen this, that in this area of avoiding FUTP, SEBI has to do so many things. Because what is happening, the technology is there, but I told you one word, to dal mein paat, this is a chor sipai game. Where always, if you are identifying certain new way, certain existing violations or existing malpractices, they search something new. So this is the continuous process in the entire world. And manipulation cannot be over in a day, because greed and fear, that is with the investor, and greed with the manipulator is always there. So they want to manipulate. The question is, I have seen various people, those who do worship, they are going to temple, they are touching feet, they are every time listening to Om Bhurvavasva, everything they are listening. But they are doing manipulation. That time they are forgetting that the loss is, the profit is yours, no doubt, but they are not realizing who is at the other side. Other side is not the person. The other side is always a small investor, poor investor, not knowledgeable investor. They are the other side. Ultimately, they are becoming fool, and you are getting money. So my suggestions to regulator, which we will compile it, and if anybody, our participant have other suggestions, they can pass on to us, and I will request my team also in the corporate official that they can compile and we will give it to. First suggestion, the uniformity and standardization is the need of our in the capital market today. Now I'll give you example, annual report. Annual report, you are making a legal it's a legal document, but investor is getting only that document. And this annual report format is not standardized in that sense. You are giving information, but you can give any other information along with the annual report. So annual report should be made now, which is simplified, it should be understandable, and it should be clearly the small investors can understand. Now you have a multiple pages, but you are not aware on which page you want to understand this. So there is a need of requirement of standardization of annual report, and for this simplification. Second, in the capital market, if you are buying and selling shares, if a IPO is there and you are investing in IPO, and simultaneously the same industries, existing companies there, and you want to invest, then one parameter is there, that is the ratio analysis. Now, everywhere, if you are comparing, the research analyst is comparing, they are comparing the ratios. So the ratio is multiple. There are thousands of ratios which are there. But there are 5 things which are very essential in the capital market. One, you want to see the efficiency of the company. Second, you want to see the growth of the company. Third, you want to see the profitability of the company. Fourth is solvency, and last is valuation. These are the 5 parameters on this. And in each 5 parameters, there are multiple ratios. So we must have the uniformity of ratios. And these are the ratios which are must ratio, must mean that every company should give ratio, and this definition of these ratios should be the uniform across the company. Maybe SEBI can bring out, SEBI can look at Chartered Accountant Institute or other institution, or they can bring out their own. The ratios should be very, very clear. What is P ratio, book value ratio, EBITDA, that should be there. Now the point is, if you see the P ratio, there is a company which has a highest P and there's a lowest P. and you are taking the average P. So this average P is not a workable, because some companies are bad, some companies are very good. So every company, there should be some system where you can identify the industry-wise P, that should be clearly defined, that what should be the P ratio of industry base. Now here, this is a interconnected thing, classification of company, that this company is in this industry. But unfortunately, if you see the NSC and BSc, you will find that miscellaneous companies are more. And the miscellaneous companies are maybe that they are in multiple business, or there's no category of these companies, so they are putting in miscellaneous. I think there should be clear-cut demarcation. The classification of companies should be there, either in the industry, which industry they belong. If they are in multiple industry, then they should say multiple industry, but miscellaneous word should be avoided. And if the company is in two business, then both the business should be given. It is not that it is a company which is coming multiple business. Then result in the newspaper, which is half yearly and monthly, half yearly, quarterly results are publishing, or yearly result they are publishing. I think SEBI has to revamp the result which is coming, because that is also companies are giving differently. Sometimes result is good and they are giving in a big newspaper. Sometimes result is bad, they are giving it in a small paper. That is the choice of the company. But the results also companies are giving in different way. So that is also there. And the columns which SEBI has prescribed, it required revamp now, which should be more investor friendly. And it should include ratio analysis also along with the result. Next is face value. The company's face value, because you can make face value 1, 2, 5, 6 or 10 rupees. So sometime the face value concept SEBI should evolve, because there was a discussion going on that it should be fractionalization can be allowed. So face value concept has to look into again, because this is one place where manipulation is taking place. 100 rupees shares, and they are making a split of 1 rupee share, and suddenly the 100 rupee shares value is going to 10 rupee. People are thinking, oh, this is a very cheap share, so they buy. So if you see split share, same value share, if you are splitting, the value will go to 20 rupees. So it means that the value is 200 rupees without doing anything. So split manipulation should also be avoided. Now, there is a disclosure, and multiple disclosures are going on in the stock exchange. But what is happening? There are two types of disclosure. One is the routine disclosure, one is UPSI disclosure, where the price sensitive information is there. Okay. Now, when you are giving information which affect the price, and the investor will understand. So results, other information which is routine should be keep separate, and all these price sensitive information which is affecting price should be separately disclosed. All the sites, all the stock exchange, both the stock exchange should keep it separate, and they should highlight this issue, that what is a new happening. Next, anyone like today, what is happening? YouTube channel, Telegraph channel, TV news, WhatsApp group. Anybody's and everybody's coming and giving gyan. They are saying, buy this share is good. Why this share good? Because I think this is good share. But now we have seen that people, recent SEBI order, you have seen people are misutilizing YouTube channel, Telegram channel, TV news. I'm seeing this Z News, ET News, other news, and I'm finding somebody who is from some broking company, somebody is from some broking company, they are giving that this share is good. Why this share is good? So he is giving logic, and we have seen this, that people were doing front running in these types of script also, and SEBI passed an order also that they were doing this. So manipulation is taking place. So number one, anybody who is giving any scripts, analysis or recommending, it should be registered with SEBI. Today, what is happening? You are saying the research report or the person who is giving research, they should be registered. But today, SEBI should pass a law and they should say no one in the country will give any gyan, India and outside both. No one give any gyan to this until unless it is registered with this SEBI, and the same SDD type of concept should be start with them. So they should record that what recommendation I have given and whether if it is recorded there. So in case SEBI tomorrow is asking, they can see. And there should be logic also that why I am recommending these shares. Now, so this SEBI can make the law for these type of people. Now, sometime these people are recommending. So I am registered. Suppose SEBI has passed the law and registered. So sometime people are recommending shares which has a value but price is less. But sometimes the value is not there and the price is going up because of some wrong information. So this type of things should be differentiated, because if I'm recommending some company, if my ratio analysis is clear, my comparative analysis clear, my standardization is there, then I will recommend with some logic. Otherwise, today, any Tom, Dick, and Harry is coming and telling buy this share, this is happening, this. So they are not only utilizing the comparative analysis in a way, but they are misleading also. So SEBI, if they can start SDD type of thing to these people, those who are giving knowledge, and SEBI should pass. No one should give any recommendation until it is registered with SEBI. Next is education. In the important thing is that there are so many investors are there. 10 crore. Do you think we say them that you should have a knowledge? But do you think knowledge can be there? ASM, GSM is one example. You are saying the company is in ASM, company GSM. How do you know? How do you think these people are aware? Or every investor is aware? Every investor is aware of that this is the information this you can get. So something should be there. Some effective education system should start, and we should not give general information. We should provide the information which is relevant for buying and selling of shares. That is most important, which we should follow. So effective education system should start. I have a doubt, and it is my personal view, that there are so many people are doing education, but whether the real education is reaching or not, because I have a habit for fear and greed. So I will not read everything. But if I'm aware the basic fundamental point that to invest in this, these are the 5, 6, 10 things you have to see, then people will focus. If we can bring out this, it will be helpful. Next is IVC type of cases. Now, this is also, I think, in my opinion, this is also one of the fraud is going on. IVC cases are there, that is filed. The stock exchange put that IRP, that the resolution process is going on. But is it sufficient? I have seen so many shares, Syntex. I have seen shares of this, the Pramil has purchased the DHFL. Now all these shares has investors lost of money. So there is a admission of the case company, then order is passed, and then in the order, if they are saying delisting, then delisting things will pass. Till that time, the trading is going on. Now, why when the company has a plan, when they are passing a resolution that they are saying, I want to delist this company, then why we are not giving them, mentioning and informing investor that this company is going to delist, because the resolution process indicates that this company will delist. I don't think this type of information is available on the system. It is very vague information, which is against, and so many investors are losing money in this. That is there. Now, another which is out of box, and some people may not be agree with this, but it is happening. Today, what is happening? The company is saying, I'm not seeing my share price movement. But after seeing this insider trading law and the market movement where SEBI is passing various orders and asking promoters and asking various people in the company, now SEBI should think that they should start something where companies should watch their movement of shares. Now, what is happening? That some third person is creating and spreading wrong information about the company, and promoters are not aware. They are saying we don't know, but it is sufficient. And sometimes you are finding that promoters are hand in glove with this information, and sometimes promoters are not knowing, and some other person is manipulating. So there should be system which they should start, that if their price or volume is going up and there is nothing in the company, then some system should be evolved where the company show motto inform the stock exchange that this price movement is against my performance of the company. Somebody is doing manipulation. They should inform to the stock exchange. So the red alert can be there. Some SDD type concept should be there. Now, why I'm saying this? Because these manipulative things has to stop, and the small investor cannot do everything. So there is one side is company, one side is investor, one side is manipulator. So the nexus you have to break this nexus, and you have to break this nexus by not only in ordinary process, by out of box thinking. So these were some of the suggestions which I have given. Okay. As ritually, after the program, when we are closing, I am taking views from everybody. What we should do, 1 minute. So Ankita, Nikita, and Ravi, what do you think, Ankita? The SEBI or stop, how to stop this manipulation? What SEBI should do?
I think that SEBI needs more legislative powers in the first place to investigate fully and go about it, because it is my personal opinion that the intentions of the regulatory body is pure and it wants to control it, but the legislative powers that it possesses has somewhat been not given properly. So this is what I feel.
So you're on mute.
Yeah, Nikita, you.
Yeah. So in my opinion, I think with time, when FUTP regulation came, it came in 2003. I think with respect to the recent judgments and the courts and tribunals has opined their view with respect to the ongoing cases or recent trends and cases. For example, one WhatsApp case was very famous, which had happened in recent times. So I think there is a need for some improvements in legislation and quick amendments like happening in other type of laws also, which are procedural laws. I think in these kind of cases also our regulations and law should be more proactively be amended in it for detecting and putting hammer on these kind of frauds and protecting the investors.
Okay, Ravi.
Yes, sir. So, sir, I second what Ankita and Nikita have said. Apart from the mandate and powers, methodologies are also in skill sets. These two things needs to be updated and regularly updated and reviewed, because the same old methodology cannot be used. Fraudsters have moved miles ahead of it. You have to be sharp and you have to revisit. I remember one episode from Mahabharata where Arjun was sharpening his arrows and Nakul asks, "Brother, you are the greatest archer in the world. What brings you to sharpen your arrows?" He says, never underestimate your enemy. You should always keep your arsenal ready. So I think there they need to work. Second is that they should also integrate technology. And see, in the Western world, there is a huge amount of literature available from Securities Exchange Commission, or you see from the UK's regulator, and how they do the investigations. In one of the webinars for insiders, I also put up a paper by Hilton L. Foster from Securities Exchange Commission, which lays down the entire procedure of investigating an insider case and the different methodologies. So I think some scientific approaches must be developed, and this AI should be used by SEBI as well. It is being used by Supreme Court. Now the courts are going to use it. So the regulators must also use it. It will help a great deal to keep SEBI in good stead. And then the third thing, sir, which you have pointed out, although it was one of the last point of your submissions, but it is nonetheless, we all know it is the most important point: investor education. If the investor is not aware, if they are not educated, nothing can be done. You can't protect a gullible person. They will be slaughtered. So in education, and more particularly your emphasis on innovative education, finding innovative ways to educate investors, this must be thirst of SEBI for today.
Okay, Ravi, because when we were doing, there are 3 questions has come quickly with the answer. When the valuation of public issue share price treated as unreasonable, who is responsible for overvaluation?
If the valuations are rendered by a professional, then the data sets which are supplied, if the methodology of the professional is wrong, if the overstatement in the methodologies, then the professional. If the numbers are manipulated, then the company.
But the question is, sometimes what is happening, you are going on perception also. Okay. Yes. So, but whatever the question somebody is asking, the valuation aspect after few scripts of recently, we must look into this. Okay. Now, one question. Supreme Court order in Abhijit Rajan infra case. If Supreme Court interpretation exceed the SEBI Act by adding profit motive, also the need for new insider trading regulation. Ravi, your view?
The second question, we can't comment. It is above our paycheck whether new regulation is required. It's a new regulation and they have come up with a lot of FAQs. So I don't think so. Currently, there is a need of new regulation. So far as Supreme Court's judgment is concerned, I mean, the person who has asked this question, don't worry, this is not contempt. You can always question the criticality of judgments. But Supreme Court has laid down the provisions because of which they have added the profit motive intention. Why there is a need to examine the profit motive? This is not beyond SEBI Act.
Okay. One suggestion somebody is giving, as per my view, investor education is key for the purpose SEBI's approach educational institution like CBSE to include these in the course to make them aware of the safeguard their money since childhood. I think this is a good suggestion. Yeah. And SEBI and the CBSE should start, because money management is the key, which is in the future. So like you are teaching ethics, you are teaching education, the health education and other things, same thing is money management. Wherever in any case SEBI impose penalty, no investor get anything who lost money by front running or insider trading. I think this is also one of the area where people should, in my opinion, what people should do, they can form their group, and then they should, not only the individual should go, all these people, those who lost money, they can make a group of particular companies and approach SEBI through said, they can directly approach SEBI and they can approach court also and ask them that they should get money which they have lost. But to prove that who is holding shares, who is this, that is some complicated, but something should be worked out. Who has lost money? If the SEBI is disgorging the amount, it should go to the investor, not the government of India. Okay. So friends, we have completed today's session. It has exceeded 10 minutes. So thank you very much to all for participating. It is a very technical subject. Now, as our journey is will continue, so our next webinar is on 17th of March, and it will be on IPO, how to prepare for IPO on main board and SME board. That is the plan, because so many companies are there. They are planning to bring out IPO